Hey everyone, Judicial Watch President Tom Fitton here with our weekly update on social media. Busy week here at Judicial Watch. We're in trial trying to uphold the rule of law in California. I'll talk about that. Big Supreme Court oral arguments this week on the abortion menace. I'll talk about that. A new lawsuit related to CRT on behalf of a teacher who was fired for daring to criticize it. Plus, we're seeking to find out the truth about the racist interview policy of Chicago Mayor Lightfoot. We're seeking to question her under oath. Plus, we have new Secret Service records about the Jeffrey Epstein scandal you want to find out about. So there's a lot going on this week. I don't even know where to begin. I guess I'll begin with the Supreme Court argument this week over the abortion issue. The Supreme Court, for those of you who have been awake, is considering, frankly, whether to overturn the Roe versus Wade decision, which essentially legalized abortion throughout the entire 9 months of pregnancy, abortion on demand. And now the Supreme Court is considering a challenge to that ruling through a Mississippi law that prohibits, in large measure, abortions after the 15th week of pregnancy. Judicial Watch filed an amicus brief. Many amicus briefs were filed, as you might imagine, asking the court to overturn Roe versus Wade. You know, in our view is, first of all, the rule of law should prevail, the Constitution should prevail, and the Constitution doesn't mention abortion. And this is essentially police power that the states have that in past history, states have been allowed to regulate abortion and to balance the right to life of the unborn human being versus the alleged liberty interests of the pregnant mother. And the Roe versus Wade decision blew all that up. And in my view, and the view of Judicial Watch and the view of many others, the Supreme Court should right the constitutional wrong and take a step back from acting as a super legislative body and restore the federalist principle that the states have a right to regulate abortion and allow the states to take steps forward, because not all states will do this, but many states will, to start to protect in more aggressive ways the rights and the humanity of unborn human beings. Judicial Watch wrote in its amicus brief, far from creating a national consensus, Roe threw the states into a 48-year contentious legal battle. Even some abortion advocates, like Ruth Bader Ginsburg, who is the deceased Supreme Court justice, eschew the injudicious method of federalizing abortion as short-circuiting a naturally evolving jurisprudence under state laws. As federal and state judges attempt to apply this court's precedents, which are kind of all over the place, a national landscape of inconsistent, inconclusive, untenable rules have emerged. As a national policy, abortion jurisprudence is, in a word, a mess. Stubbornly holding on to an unconstitutional precedent will never have a positive outcome. It is time to return abortion policy to the states where it belongs and where the democratic processes can effectively work. And as I noted in our press release related to the decision or the oral argument this week, states must be able to defend life, and the disastrous Roe decision has upended our constitutional order. The Supreme Court has a chance to right a constitutional wrong that will allow the states to step in and begin to protect unborn human life. So I don't know how the decision is going to go. I encourage you to listen to or read the oral argument. I think we can probably provide a link to the Supreme Court website. There should be at least a transcript of the oral argument. The justices, I think there's a majority of the justices that will uphold this law. And I guess the question is there a majority that will overturn Roe versus Wade in its entirety? I'm not sure if that's the case. I suspect it will be at least 5-4. In that regard, Chief Justice Roberts, per usual, is trying to walk a middle ground here and seemed upset in some ways that he was being even asked to consider this issue. So we'll see how it turns out. I've often joked, and many have often joked, that in order for the abortion on demand decision which is one of the worst decisions in the history of the Supreme Court to be overturned, that Republicans will have to appoint 9 justices, and it will still be 5-4. So it's going to be a close-run thing. What struck me as president of Judicial Watch was the intemperate remarks of Obama appointee Sonia Sotomayor, who is a Supreme Court justice, who talked about the stench of the decision-making process if the court overturns Roe versus Wade, because evidently we're not allowed to overturn decisions she likes, but we can overturn decisions she doesn't like. And she's essentially attacking the ethics of her colleagues on the Supreme Court in open court. It was a remarkable thing to see, and kind of sad to see and outrageous to see. But it shows you that the rule of law for these pro-abortion fanatics, including Sotomayor, who is a fanatic on the court in this area, everything gets tossed aside. Judicial temperament, judicial ethics, the rule of law, constitutional government, the idea that we protect the vulnerable in our society. And one of the things we didn't mention in our amicus brief, in our friend of court brief, that's worth mentioning, of course I don't think they asked about this at the Supreme Court, is what has Roe wrought besides the deaths of millions of unborn human beings. Is it's created, as Judicial Watch has taken the leadership in exposing a market funded with your tax dollars for the fetal body parts, organs, heads, livers, thymuses, things like that, of them to engage in Frankenstein-like scientific research. Humanized mice research Judicial Watch has exposed. So this abortion regime obviously is destroying our next generation, but it's also creating this barbarism in our scientific community, because all these dead unborn human beings are seen as a resource for scientists who have little grounding in ethics and morality, and for politicians who are willing to spend your money to help them use these unborn human beings in Lord knows what processes related to the development of drugs, or, as the FDA has admitted, to ensuring the safety of vaccines. So that was the FDA's response to a recent Judicial Watch disclosure that the FDA was funding fetal organ chop shops. So that's what Roe has wrought. I guess that's kind of hard to say. Roe has wrought, which is not only the deaths of unborn human beings, but this barbarism in the scientific community that I think we'll be regretting for the rest of our history. So I suspect the court will issue its ruling probably the middle of next year, by June or sometime in June. So we'll see. In the meantime, Texas has a law that is still in effect that protects human beings in the sense that unborn human beings with a heartbeat are prohibited from being killed through abortion. And the left is apoplectic over that. I mean, that shows you the extremism of the pro-abortion group that is controlling our media, controlling our government now, and unfortunately has been controlling our judiciary. So hopefully that we're able as a country to move forward to expanding the right to life to include the most vulnerable, the unborn. So we'll see what happens. And God bless Texas for taking additional steps. God bless Mississippi for taking steps to try to protect the right to life. And hopefully Roe, the abomination, will be overturned, and additional states, and maybe even the federal government, can then begin to take steps to protect the right to life of innocent preborn human beings. Well, Judicial Watch is, as I've said before, front and center in the civil rights battle of our time, which is the battle against CRT, critical race theory. And I say that with a little bit of irony, because those who promote CRT pretend to be in favor of civil rights, when in fact they're promoting discriminatory activity, discrimination based on race in our schools, in our military, in our government, and in our corporations. And woe to you who take this on as an issue. As a parent, if you go to school board meetings, the Biden administration considers you to be terrorists potentially. If you're teachers and you object, you face getting fired. If you're in the military and you object, Lord help you as well. This is a fanaticism that obviously is seeking to propagandize and transform our school children into little Marxist agitators. But anyone who gets in the way, they'll roll right over. And that includes a new Judicial Watch client who was a Massachusetts high school teacher who was fired over posts she had made prior to her being a teacher for opposing CRT. Her name is Carrie McRae. She was fired in retaliation for posts on social media objecting to the inclusion of critical race theory in schools. And what she had been doing was she had been running for office for the school committee there in Bourne, Massachusetts, and she got elected. And as part of her campaign, she posted a TikTok video. And this is the terrible thing she said on TikTok. So pretty much the reason I ran for school board and the reason I'm taking on this responsibility is to ensure that students, at least in our town, are not being taught critical race theory. That they're not being taught that the country was built on racism. So they're not being taught that they can choose whether or not they want to be a girl or a boy. It's one thing to include, and it's one thing to be inclusive, and it's one thing to educate everybody about everything. It's completely another thing to push your agenda. And with me on the school board, that won't happen in our town. So she has a straightforward, conservative view held by millions of Americans that sensitive issues related to the Marxist attack on our country and the radical agenda related to transgenderism be policed in more significant ways by school boards. So she gets hired a few months after those and other social media posts, and someone finds them, and the school board and the school committee for the other school district where she was working. So what's interesting is she wasn't working in the school district in which she was a school board member. She went and got hired at Hanover High School at the Hanover School District. And they fired her. They brought her in almost immediately upon her being hired, and as soon as this material got into the public domain, I guess some leftists didn't like what she was doing and tried to, they didn't even know she was a teacher when she posted this. She gets hired, they bring her in, and they say, based on your school, on these social media posts, you're going to get fired. As she said, Carrie McRae said, I got fired specifically for a social media post I made. This is a violation of free speech. So she gets called in, and this is the letter they sent her. I have determined that continuing your employment in light of your social media posts would have a significant impact on student learning at HHS, which is Hanover High School. And she got fired. Our lawsuit details, so we filed a lawsuit for her on behalf of her, charging retaliation for her First Amendment protected speech. The lawsuit details that no Hanover High School parent or student had raised concerns about her employment at the school because of the social media posts. So this was kind of, again, I keep on calling it this fanaticism, where you have these folks who are so desperate to push critical race theory that they will trample on the civil rights of parents, and in the case of our client, teachers who oppose their agenda. And frankly, didn't really do anything to oppose their agenda as teacher. McRae had made this post months before. There's no evidence she was doing anything even in the school, even though that probably would have been her right. So this is really outrageous. And it's not going to stop. It's getting worse. And we've got the Biden administration targeting, as I said, parents who are daring to speak up. We have the school boards lying about critical race theory, trying to pretend it's not happening, and keeping files on parents in some circumstances who object to it, attacking parents who object to it, trying to keep what they're doing secret so that parents are kept in the dark about how their children are being taught. And this parent, this person, Carrie, goes and runs for public office, gets elected to the school board, and months later, her mainstream comments on this issue get pulled out and used against her. And frankly, even non-mainstream comments would prevent her from being, there's no good reason to fire her over anything she said. The First Amendment protects your right to petition your government, and you can't be punished by government officials like the school board is doing to our client. And of course, this isn't the only case. You may know we're representing Coach Mike Flynn, who was fired as a high school football coach because he objected to his middle school daughter being force-fed this Black Lives Matter and critical race theory propaganda. So there was retaliation there. He objected as a parent and taxpayer. We have a teacher in Illinois, Jean Hedspeth, who was fired by her school district because she put up Facebook posts mildly criticizing the Black Lives Matter riots that were destroying her cities. So they're coming after anyone who objects to this. And Judicial Watch has filed 3 federal civil rights lawsuits to try to vindicate the rule of law and to protect the rights of teachers and parents to object to critical race theory. And we have numerous Freedom of Information Act requests out there that have exposed critical race theory in places like Loudoun County, Virginia, the biggest school district in Maryland, Montgomery County, up in Rhode Island. I think we've got material out of Massachusetts, and we've been helping quietly parents throughout the land, throughout the country, try to get information from their school districts about what's been going on here. So we're not going to back down. I don't know about you, but Joe Biden threatening to sic the FBI on parents for objecting to CRT ain't going to stop Judicial Watch from continuing to find the truth and uphold the rule of law here. So this is our latest lawsuit. You can go to the website, learn more about it, and I encourage you to support our work in this regard because this is where your donations go to. You help us do work like this. So and Judicial Watch is firing on all cylinders this week. We filed a lawsuit in California that's now at trial. We have 4 lawyers in Los Angeles before the Superior Court there. There's a bench trial, so the trial's before a judge, not a jury, in our taxpayer challenge to California's gender quota mandate for corporations. They passed this law that they knew was unconstitutional under the California state constitution that required corporations, more or less, to have a certain number of women on the boards of directors. So think about that. They're requiring sex discrimination. So you have these radical leftists running California trying to upend and blow up decades of anti-discrimination law as they pursue their critical theory. So, you know, we talk about critical race theory, but just think of it kind of as critical theory, which is that whatever the issue is, race, gender, sexual identity, the traditional Marxist talks about class. Now it's all developed under this rubric of critical theory, and the rule of law must be cast aside. Protections to you as citizens who should be treated according to merit as opposed to based on race or sex should be cast aside. They want to go back to where you could discriminate on the basis of race and sex. So taxpayers have a right in California to challenge taxpayer funds that are being spent on illegal laws like this. And so we filed this lawsuit. We went through, I don't remember when did we file it. I think we filed it in 2019. So it's been going on for some time. And the case is now before a judge. So our lawyers are out there versus the California lawyers trying to convince a judge to rule in our favor and rule that this California gender quota mandate is unconstitutional and a violation of California as a constitution, and that our taxpayer clients should be vindicated and it should be ended. We want to end it through this taxpayer lawsuit. This is the brief we prepared for the trial. Even time spent by public officials carrying out an unlawful act can be enjoined, Applications of the law as written will result in a state official expending taxpayer funds on an unlawful law unless the expenditures are enjoined. California's Equal Protection Clause is clear and well settled. When the challenged statutory scheme employs express gender classifications, a plaintiff meets his or her burden of establishing unconstitutionality by pointing that out. It's pretty simple. It's illegal. We're pointing it out. We should win. It's undeniable that SB 826 expressly employs a gender-based classification. The law requires a predetermined number of board seats be set aside exclusively for women, or females as defined. Accordingly, plaintiffs will have satisfied the fourth and final element of their constitutional claim based on the statute itself. The burden of justifying SB 826's express gender classification shifts to the defendant, meaning it's up to them to prove that what they're doing is legal. And I mean them being, it's up to the California state officials who are being represented by taxpayer-funded lawyers in court right now. Frankly, a new study, now this is really interesting. Now, their new argument is, it seems to me ever-changing, is that this actually helps California businesses, as if that justifies racial discrimination. That's what they're thinking. They're saying you're helped by being forced to engage in sex discrimination. And in fact, a recent study found that there was a robust and significantly negative stock reaction to California's gender quota mandate. So it's bunk. What they're arguing is bunk. In our case, I think, as I was talking to our team this morning, our case is, we're presented, it took, I think, only a day and a half to present our case. The government wants, I think, 2 weeks or more to present their case. So let's pray for success. It shows you that Judicial Watch is on the cutting edge of all of these issues. And we could, this is a very closely watched case. We have the media there. They've been following this. The business community had been following this. Businesses generally opposed this, but they were afraid to take the state of California on. So it's up to Judicial Watch and our brave taxpayer clients who are pursuing this. Just regular citizens we're representing, but they're taxpayers, and they're just like you. They don't want the government to engage in illegal conduct. They don't want the government to require sex discrimination. They recognize it as illegal, and they object to their tax dollars being used to pursue this illegal activity by the government. Frankly, the Supreme Court, Jerry Brown, when he signed this law, the former governor of California, he raised questions about whether it was legal or not. And I can tell you, don't believe that it's just going to be in California. You had NASDAQ, the stock market exchange, have a soft quota requirement for boards of directors. They say, we want to know, we want you to do all your racial, gender, and sexual identity bean counting and report to us how many of each you have on the board and tell us why you don't have enough. So it's not, quote, going to be a requirement, but look, you know what corporations are going to do in the face of that sort of request. They're going to engage in unlawful discrimination. So we are taking on the left's assault on the rule of law, assault on anti-discrimination laws, and it kind of highlights how the extremism at the left, exposes their true motivations. They don't believe in protecting people from discrimination on the basis of sex. They don't believe in protecting people from discrimination on the basis of race or any other of the classifications they think we're supposed to be given special treatment to. In fact, they don't believe that. They think all those protections against discrimination for whoever they say needs to be protected, they don't actually believe that because they want quotas, which means necessarily that people will be discriminated on the basis of the classifications the law currently supports or protects. So I don't know how the trial is going to go. It's going to be up to the judge in the end. But I'm proud as heck that Judicial Watch is in trial And the reason we're in trial, as I said before, is because of the support of people like you. We have hundreds of thousands of Americans who support our work, and it allows us to go to court and take on the entire state of California, the government of California, who has unlimited resources, but because of you and other supporters, we're able to have the resources to take them on. So it's just great, absolutely great. Speaking of taking on government misconduct and racially discriminatory activity, we sued Chicago Mayor Lori Lightfoot over her racist interview policy. You may recall that she had a policy of only granting interviews to, quote, journalists of color. Frankly, she doubled down on it and was unapologetic about it. So we filed a lawsuit on her behalf, on the behalf of the Daily Caller News Foundation and reporter Thomas Catenacci against Lightfoot for violating their First Amendment rights and Catenacci's right to equal protection under the 14th Amendment. It's a civil rights lawsuit. So these civil rights lawsuits I'm talking about, they're called, kind of the shorthand way of calling them, the law that allows them to be pursued is known as the Ku Klux Klan Act. So Chicago Mayor Lori Lightfoot is in violation, in our view, of the Ku Klux Klan Act. And so that lawsuit's been proceeding. We had some discovery there. The mayor's office was supposed to give us a representative that would explain what went on. That representative didn't have the answers I think the court needed, or our lawyers thought the court needed. So we're seeking to depose defendant Lori Lightfoot. As we say, Lightfoot breached her obligation to designate a person or persons to testify on her behalf concerning the topics authorized by the court. From the earliest moments of the deposition, it was beyond clear that Mayor Lightfoot failed to produce a witness who could testify to the factual issues raised in her motion to dismiss and within the scope of the court's order. So, in response to that failure to tell everything that they're supposed to tell Judicial Watch, our clients in the court, we are seeking a court order to depose Lightfoot herself in person on oral examination, meaning bring her in and question her directly. So we'll see what the court does there. But when you have the mayor of a major city, Chicago, inform multiple reporters that she would grant one-on-one interviews only to black or brown journalists, where are we as a country if that's going to be allowed and to be normalized? Testimony in this lawsuit confirms Lightfoot is responsible for her racist interview policy, so she is a necessary witness in this litigation. So we'll see how the court responds there. But this is what I love about Judicial Watch. Everyone sees this outrageous activity, but few people do anything about it. And we try to figure out ways to hold government accountable when they engage in misconduct. And in this case, Lori Lightfoot is violating the civil rights of our clients, and we have a civil rights lawsuit in federal court holding her accountable. And I hope we win, but I think it's important that we even file lawsuits like this to remind Mayor Lightfoot and other people like her that they are accountable to the rule of law and they can't discriminate on the basis of race on behalf of their, again, advancing this critical race theory agenda without being held accountable or being asked by a court to defend what they did. Boy, so a lot else is going on, including something else that's very interesting. We've always been very interested in the issue of Jeffrey Epstein, the friend of Bill Clinton, who allegedly committed suicide. I'm not convinced it was a suicide. He's been alleged to have been engaged in all sorts of sexual misconduct, improprieties, child trafficking, you name it. His friend, how do you pronounce her first name now?
Ghislaine.
Ghislaine. It's spelled Ghislaine. It's pronounced Ghislaine. Ghislaine Maxwell is on trial right now in federal court over sex trafficking and other charges. Now, Judicial Watch had asked for documents about the Epstein matter. We had asked the Secret Service, I recall, for documents about any of the trips that Bill Clinton took with Epstein to his Caribbean island. As best I can recall, they gave us a no records response, and which is odd since I think he actually did go to the island with him. So I don't know why there were no records, but you know, we can't force them to give us records they say they don't have. On the other hand, we did ask for Secret Service documents about trips Maxwell may have taken with Bill Clinton, and we did get back documents. And we got back Secret Service records that show that he went on a trip with Maxwell to India back in 2003. Now, there was a podcast that had suggested that that trip had taken place, but this is, as best I can tell, the first official government confirmation that it took place. And draw your own conclusions from it. What was Bill Clinton doing with Ghislaine Maxwell in India in 2003? And I have some other questions too. Has the Secret Service, who was protecting Bill Clinton, been questioned about anything he was up to in the presence of Jeffrey Epstein? Do they have any information about what Jeffrey Epstein was up to? Did the Justice Department question the Secret Service agents who were providing protection for Bill Clinton? They're not immune from being questioned for issues like that. So that's the sort of thing I have questions about. But again, Judicial Watch is doing this basic investigative legwork to find out about Maxwell and Epstein's connections to Bill Clinton. So it was just 4 pages of documents, but they had a big impact in the sense of proving, of exposing a trip with that Bill Clinton took with Maxwell to India. You know, the Clintons were very close to Maxwell. She was at the wedding of Chelsea Clinton. I think I saw pictures of it. But there's been other information out there that they were very much involved in the operations of the Clinton Foundation and its fundraising. So I think there's still a lot of questions to be asked about Bill Clinton and Jeffrey Epstein and Ghislaine Maxwell. So with that, I don't know what else I could possibly talk about. I guess there's always other things to talk about. But you can see Judicial Watch, as I said, is firing on all cylinders as we pursue justice and the rule of law. And I'd like to thank you for your support, and I will see you here next time on the Judicial Watch Weekly Update.